The Connecticut Rental Agreement. In this video, we will tell you about the most noteworthy aspects of rental agreements in the state of Connecticut. What is a rental agreement? A rental agreement or a lease is a document that outlines the arrangement between two parties regarding a property rental. The one who's paying rent is called a tenant, while the owner of the property, who lets the other party use it under certain conditions, is called a landlord. The parties may also be called a lessor and lessee. Typically, a rental agreement lasts for 6 or 12 months, with rent being paid every month or every week. There is one federal disclosure that works for all lease agreements in the United States. This is called the lead disclosure, and it requires the landlord to tell the tenant about all known lead paint hazards. They should also provide the state-approved version of the pamphlet, Protect Your Family from Lead in Your Home. However, this requirement applies to not all types of residential dwellings. Required disclosures. Apart from the above-mentioned disclosure, there is also some more information the landlord should disclose in a rental agreement. The landlord's name and address. Common interest community notice. Operative fire sprinkler system notice. And bed bug disclosure. Security deposits. In the state of Connecticut, the maximum security deposit is 2 months' rent for tenants age 62 or younger, and 1 month's rent for tenants older than 62 years. The deposit shall be returned by the landlord within 30 days after the termination of the tenancy, or within 15 days of the tenant providing their forwarding address, whichever is later. If any damage is caused to the premises by the tenant, the landlord can use the deposit to pay unpaid rent and to repair any property damages. In such a case, the tenant should get an itemized list of withholdings. If the landlord fails to mail the security deposit or an itemized list within the set period, the tenant can receive up to twice the security deposit. Landlord access. In the state of Connecticut, a reasonable written or oral notice is required from the landlord before entering the rented premises to inspect them, make necessary repairs, etc. An entry is allowed only at reasonable times. Termination of agreement. For termination of any lease in Connecticut, a 3-day written notice is required from either of the parties. Notice periods for non-payment and non-compliance. A 3-day written notice to pay or quit should be sent to the tenant if they fail to pay the rent within the 9-day statutory grace period for all leases except for a week-to-week lease. For such agreements, the same notice should be sent if the tenant fails to pay the rent within the 4-day statutory grace period. A 15-day written notice to remedy the violation or quit should be sent if the tenant violates lease in any other way.